Good morning, good afternoon, or good evening to everyone. It's my great pleasure to welcome you to the Judicial Roundtable discussion on commercial litigation funding as part of the third meeting of the Standing International Forum of Commercial Courts. It is a privilege to be able to meet online in this virtual auditorium, despite the challenges of the COVID-19 pandemic, and I'm pleased that we can bring together a truly international community. Today we are joined by delegates from Africa, the Middle East, Asia and Australia. I want to thank all those who made the pre-recorded contributions, which were so valuable to our discussions today. I'd also like to particularly welcome in our session today, Minister Tong SC and Justice Middleton. I'd also like to thank Lord Thomas, the Planning Committee of the Forum, Chief Justice Menon and the Supreme Court of Singapore for the extraordinary achievement in making this conference happen. Before we begin, I'll quickly run through today's session. I'll first make some brief opening remarks. I'll then open the roundtable discussion to everyone. If you would like to ask a question, make a comment or express a view, please use the virtual raise hand function. If I call on you to speak, I'll send you a request to unmute your microphone. After you finish your contribution, please mute your microphone and lower your virtual hand. Commercial or third-party litigation funding is becoming more prevalent globally in class actions and other civil and commercial litigation and arbitration matters, especially with the decline and probably fall by now of the common law doctrine against shampooing. Our different jurisdictions take different approaches and come from different policy standpoints. Today we have the privilege to watch or read resources from our contributors, which will provide the basis for our discussions today. From Minister Edwin Tong, we've heard about some of the benefits and issues of commercial litigation funding, the role of funders within a justice system, the Singapore experience of light touch regulation and international experiences. An important theme which emerged was the access to justice component of funding arrangements. Do funders serve a public interest? The example of Singapore's model for international arbitration brings up questions of how successful the framework is at striking a balance between a need for regulation and parties' autonomy. How much disclosure and oversight is necessary? And can we or should we strive for international consistency? From Ms. Susan Dunn, we have heard about why commercial litigation funding developed and the role of regulatory bodies in different jurisdictions. Questions emerge about how litigation funding can refine issues and encourage only meritorious actions, and whether smaller claims with merit fall by the wayside. And for jurisdictions with self-regulation, how can we regulate the actions of funders who do not join a funders association? From Lord David Hope, we heard about the ways a court may shape and set limits on the activities of commercial litigation funders. We may consider these rules about litigation funding agreements. Do these or similar have broad scope for international application? How do practitioners respond to court rules? And as judges, are we facilitating broader accessibility for litigants? Is closer court supervision of funders appropriate or inappropriate? From Justice John Middleton, we've read some of the findings of the Australian Law Reform Commission's inquiry into class action proceedings and third-party litigation funders. Do these recommendations have purchase internationally? How can we mitigate against risk from third-party influence over proceedings? Should courts have the power to reject or vary third-party litigation funding agreements in the interest of justice? These four contributors have left us with real scope for topics to grapple with together. What I think has emerged from these contributions is that commercial courts in all jurisdictions are facing similar challenges from the increase and general acceptance of litigation funding. The challenges involve preserving the integrity of the courts and the interests of litigants, whilst recognised the benefits which can be gained from funding, which have been outlined, for example, by Ms. Dunn in her contribution. There is general agreement among all contributors that some level of regulation is necessary, but I think issues remain as to whether that should be done internally by litigation funders, by legislation, by the courts, or by a combination of all three. There are also clearly issues concerning client autonomy, legal professional privilege, potential conflict by the lawyer conducting the litigation on behalf of the client, and the degree of supervision courts should have over the return litigation funders should obtain from conducting a litigation and whether that should be determined at the end or at an early stage in the proceedings. I think this will be a useful time of collaboration, learning and sharing. I now open the session. Please use the raise hand function to make a comment or ask a question for discussion. Can I open it then by asking a couple of questions from my side? What is or can be the impact of commercial third-party litigation funding within a justice system? How do we achieve high standards? If regulation has a part to play, how's it currently being used? Who should regulate? What is the role of the courts? I'd appreciate anyone's views on those questions at the outset. In the absence of any takers, could I call on Chief Justice Manor? I'm sorry. Red. She's got the head now. Can I call on Chief Justice Alsop to make some remarks?
In the absence of Justice Middleton speaking, I saw him there. This issue has been very live in the federal court as it has been in the Supreme Court for some time. We have recently had our implied powers of control cut back by a High Court decision. An implied power that was being used by judges in various ways to control what they saw as excess in terms of privately arranged funding agreements. And ultimately, I think one view, I think, and it's a common view amongst my colleagues, is that the courts are in the best position of all to know exactly what's going on in cases, exactly how stresses and strains of conflicts of duty and interest are playing out or might be playing out, and that the courts are well placed to at least regulate those, if not regulate price control. But with the use of techniques such as reports from referees or independent parties that may focus on commercial aspects of these funding arrangements, that the court is perhaps not as well placed to address independently. With those qualifications, that the courts are actually quite well placed to exercise power in relation to this if they have a foundation in statute for it.
Thank you. Minister Tong.
Thank you, Chief Justice Bathurst. As I said in the speech I made, which I recorded a couple of days ago, we started on this journey looking at it in a very limited way first to begin with. And we did so because we're a jurisdiction that traditionally looks at champity and maintenance with some amount of uncertainty and skepticism. And we were a lot more conservative previously. But I think we looked at third-party funding as opening up the prospects of pursuing meritorious litigation. We looked at around the world. Many other jurisdictions have used this, especially in the context of international arbitration. So we decided that we would start small in a narrow way and introduce it only to certain prescribed categories to begin with. And we looked at international arbitration, we looked at certain types of mediation related proceedings, and also certain arbitration type proceedings. And we are looking at whether we can expand this to certain other categories in the narrow. And we thought that the best way of doing this is initially at least to be soft on overt regulations. So we gave a framework, and we felt that the best way of doing this was to prescribe the categories and also put in regulations in the context of professional obligations on the part of the solicitors, the lawyers. And eventually also, in the third protection for that, as it were, was to look at the nature of the funder and to ensure that the funder was qualified, had the financial ability, and had a certain level of standing before the funders would qualify as appropriate funders in the context of these agreements. So we've started in that context to look at it narrowly. We are now studying the extent to which some of these categories can be broadened. And we are also looking at the experiences of other jurisdictions to look at safeguards and controls and to see the interplay between giving party autonomy, but the flexibility in arranging your own terms with the funders, and the degree of oversight that one should have, either in the context of judicial oversight or also what we might prescribe by way of regulation. Thank you.
Thank you. Chief Justice Menon.
Thank you. Thank you, Tom. Actually, what I wanted to say segues somewhat from what the Minister just said. And my observations really come down to this. I think it's helpful to take a step back and to think about what is the purpose that drives our attitude towards litigation funding. What is it that we're trying to do when we permit litigation funding? And in turn, the flip side of that, what was the rationale for preventive doctrines such as championship and maintenance that existed in the past? And I'm not for a minute saying that what happened in the past is sort of inherently superior, that we're locked into that. But I think it's helpful to ask these questions in order to inform the way we think about them. And it seems to me that there are two primary ways of looking at this. We could think about litigation funding from the point of view of the access to justice function that it serves. The Minister touched on that. There's undoubtedly a case of certain types of meritorious claims that don't get off the ground because there just isn't the money to give you the lift off. So access to justice is clearly one aspect of that. On the other hand, there's a real danger, I think, that you end up with litigation becoming a business activity and the conduct of litigation being pursued in and of itself as an economic activity that is there to drive and generate profits. And I think that that's what the common law doctrines were there to prevent, because litigation was fundamentally seen as inseparably tied into the administration of justice. And being inseparably tied into the administration of justice, it was thought that we shouldn't allow it to become a profit-making activity. So when you look at those two things, I mean, they're not necessarily binary, but there is a real danger, I think, that if we don't go through the process of thinking through all of these issues, there's a real danger, I think, that we end up finding a potential conflict between these interests. And I think that, in my respectful view, I think that was very much sort of behind the thinking of our government in taking an incremental approach by choosing areas where the access to justice concerns might be less directly impacted by the litigation funding being allowed. To me, what I think this signals is the following. I think if you look at these two different purposes, access to justice can be met in a number of different ways. I think, Tom, you're familiar. In Australia, you have long had systems such as conditional fee arrangements where solicitors can waive fees up front, and then if they're successful, there's a limited amount to which you can get a premium for having taken the risk, and you reward them by giving them some markup, and that's subject to the control of the courts. So there's some way in which you can maintain some degree of proportionality. And I personally think that those kinds of approaches are very much in keeping with the access to justice function without running into the dangers. The problem with litigation funding, if we don't have some degree of regulation that gets to it at the end of the day, I think, is the reality that it's also going to drive unmeritorious claims. And once you think of litigation as an economic activity that is there to generate profits, some of those profits are going to come from advancing unmeritorious claims and trying to get settlements, trying to get a portfolio of meritorious and unmeritorious claims, generate different types of economic products that you could market, and this is not beyond the pale. So I think we have to watch that space carefully. The second point I would point to as a concern that we need to think about down the road is the real prospect that we end up with a situation where the business of arbitration and the business of commercial courts is seen as the interests of the rich, and then domestic litigation is seen as the interests of those who can't afford it. And if we get, there's already quite a lot of academic literature and people who've been writing about the fact that arbitration is essentially things that's there for the rich in society. It's not really there for average users of the system. And I think we have to watch that space quite carefully, that we don't end up ossifying that divide and that view of justice.
Can I just add two things running from that? In Australia, we've had experience where litigation funding has been used, not in the commercial context, but in other contexts where I think it has proved beneficially. There's been large litigation in the federal court and substantial litigation in this court from people who have been impacted either by medical devices or, in the case in this court, very substantial floods, which were caused allegedly by negligence of the Queensland government. The other thing I want to say is that I don't know if this is an experience anywhere else. There is a real concern in this country that the extent of funded litigation in the corporate area is impacting on the ability of directors to get directors and officers insurance. And there has been some threats, I don't know if they've been materialised, that insurers just won't come to the party, which is going to have very deleterious effects in the long term on the economic activity in this country. I don't know if that's been the experience of anyone anywhere else. Could I ask Justice Middleton to make a few remarks? I'm sorry. Yeah.
Excellent. Thank you. I would like to make some comments really directed to representative proceedings and litigation funders, and that's just a subset of the whole story, obviously. Indications are that in Australia, reform in this area is very imminent. There's a push for legislative reform to give a greater balance now between the lawyers, the funders, group members, and various defendants. And the problem over many years has been the emergence of cases where there's a minimal return to, as we all know, meritorious class members, but the legal costs and the funding costs being large and out of all proportion to the return to the class members. I personally think that the approach that has been adopted by judges, which is pretty broad and supervisory over many aspects of the capital of the adequacy of funders, commercial terms of the funding agreements, and dealing with funding commissions where they're excessive has been good. Now, as I think Minister Tong said in his pre-recorded session, as in Singapore, I think judges are trying to deal in a practical and effective approach, which we have to take and we've had to take because there's been no real regulatory oversight. Now that may change and deal with the main areas of concern, which the size of the return to the funders, the potential of the funder to actually control the proceedings, and then, of course, as we all know, various conflicts that arise between the funder, the class members and whatever. I personally think, and there may be different views about this, that the court should supervise commercial terms of litigation funding. And in the Federal Court of Australia, litigation, the actual terms of the agreement have to be disclosed to the parties as well as to the court and to the class members. There are obvious redactions to protect any confidential information or in instance of legal professional privilege, but at least it's out there for everybody to see. As you will observe, that's may change. Thank you.
Could I ask the Chief Justice of Sri Lanka to say something?
Thank you. And But first, I would like to thank the SIFoCC for including this important topic for discussion. Coming from a jurisdiction that we are not faced with this issue much effectively so far, but it's very important to consider all these aspects that were mentioned by CJ, New South Wales, as well as the Chief Justice of Singapore. One observation that I could make is that we need to ensure that the process of litigation should not be allowed to be exploited as a business enterprise by some of the funders. So that's the area perhaps that we will have to focus very carefully and then balance the interests of access to justice with these observations. So these are the observations that I can make because I have very limited experience on this matter in the jurisdiction that I represent from. Thank you.
Thank you very much, Chief Justice. Justice Lowe.
Can you hear me?
Yes.
Good. I just thought I'd like to add two things to the points brought up by the other judges. The first point is this. I think there will come a time when some jurisdictions will require third-party funding to be made known. And once that is done, I think judges and arbitrators will have to then start dealing with this question when the other party says, I want security for costs. Because if the funded party goes down, you may have no recourse against the funder for costs. The second point I wish to bring up is I wonder if the United Kingdom judges could help us out on this. There was for a time some, I don't know if it's still there was a time when it was common to get what they call after the event insurance. And this was insurance to deal with the outcome of an action. And I was told it actually brought a second round of litigation where the insurers went after the lawyers who assessed the viability of a defense or a claim. Do we make sure this doesn't happen? If it did happen in the UK, because there was some resistance getting ATE insurance in Singapore because we felt it was a real enough nightmare to have a second round of litigation against those people who advised on the claims prospects or the defense prospects. Thank you.
Justice Knowles, would you care to comment on that?
Thank you. We've certainly experienced litigation in the advent of ATE insurance, but that was our experience every time new costs initiatives were undertaken. One of the broad lessons I think it has caused us to take on board is that it's very important to try and be thinking ahead on areas of costs and funding as a system, rather than simply allow practices to develop, which then spills into problems, spills into litigation, and one is left with a rearguard approach to a holistic model. May I add this question though, because it to me represents part of the challenge. It's one thing to think about controlling the funding, but another way in which a third party can take the effective reins of a claimant is to acquire the corporate party or to acquire control in the party. That can bring litigation activity with the type of disadvantages that have been identified, and we need to think ahead to that too, I think.
Thank you. Chief Justice Alsop.
Just three comments on some of the things that have been raised. Whilst I understand and sympathise the notion that the administration of justice should not be commoditised, that's exactly what it is, I'm afraid. And the funders are not there as professionals, they're there as funders to make money. And it's the proper control of them, I think, that is any excesses. Secondly, the fear that this will promote many bad claims, I'm not sure is correct. The funders would prefer to win, not lose, and at least to the extent that we can see it, there's often fairly rigorous due diligence by the funders in what cases they will take. And it does produce an equality of arms for people who can't necessarily afford the same quality of counsel and representation. And thirdly, as to security for costs, that's exactly because we make the funding arrangements required to be known, security for costs is almost will almost always be granted in commercial cases with funders, unless the circumstances otherwise don't warrant it because of the size of the party. There are some exceptions to that in no-cost jurisdiction, no-cost litigation, but security for costs will generally be awarded.
Thank you. Justice Reardon from the Supreme Court of Victoria.
Thank you, Chief Justice. I just thought I would report on the recent approach that's been taken in Victoria, because they have now introduced what's called a group costs order. A group costs order is in fact a legislated contingency fee, which we've never had, I think, anywhere in Australia before. And it's done on the basis that the firm of solicitors can apply for a group costs order, and the court will make an analysis of what percentage of the total award the firm should be entitled to charge. Plainly enough, on that basis, the solicitors have to take the responsibility for the conduct of the action, and also they have to take responsibility for providing security for costs as a matter of legislative requirement. And that is an interesting attempt to get around some of the problem. And I don't know what the High Court may ultimately say about the courts intervening in setting the relevant percentage, and the Act gives no indication of how that will be determined. The first of the applications for such a group cost order is being heard soon and probably will be determined before the middle of the year. And we will have to sort out within the court what are the guidelines, parameters and features that we use to determine what evidence we'll need. There's been an attempt to survey evidence by economists and accountants and the like, but it does mean that as the solicitors will effectively become the funders, the court will have quite a deal of control over the percentage and over the conduct of the solicitor stroke funder.
Thank you. We've heard quite a lot from representatives of Singapore and Australia, but I'm sure this is a problem that is involving other jurisdictions as well, or maybe they're lucky enough that it doesn't. But I'd like to hear from some of the other jurisdictions who are at the meeting as to their experience and the problems that they're having. I'm told as host I've got power to call on people, so I might ask Chief Justice Chung from Hong Kong to say a few words. There. Didn't work, did it? That wasn't particularly successful, I'm sorry. Could I have any volunteers? If you are, Ms. Dunn. Thank you. Not unmuted.
Can you hear me?
Yes, thank you.
Okay, I recognise I'm not a judge, so just for the record, I do recognise that. So, but I just thought, perhaps in the absence of anybody else, given that we fund in many jurisdictions around the world, I could just give you a little bit of insight about a couple of jurisdictions there, but only if there's no other judges who wanted to join in. That was all.
Please go ahead.
So we've been involved in the development of legislation and regulation in a number of statutes in a number of jurisdictions, including, for example, Hong Kong, which currently permits funding only for arbitrations. And so far, there's been almost no take-up. Even though that has been permitted for some number of years now, there's been almost no take-up of funding in Hong Kong. And it remains that we only get applications in relation to insolvencies in that jurisdiction where it was always permitted. I guess that what we'd see across jurisdictions, and I think the points that have been made are really interesting about the themes that one sees. I think we mustn't forget the role of the lawyers running the case in all of this, as well as your roles as the judges of the cases. And I think, of course, you understand the case very well. One of the challenges that we face, and this point about funders ending up with large commissions, is because there is, in our experience, I've been doing this for 20 years, lawyers tend to massively overestimate what claims are worth at the outset. And that leads to a tension then at the end when it comes to looking at what's been awarded between what was terms assessed based on one particular value, but then the outcome is much smaller. And budgets also tend to regularly overrun. So I think their role is very important in terms of being more realistic. And we're working with a lot of firms now to say, look back at the data that you had, and I know your first session was technology, but look back at the data of what you estimated a case to be worth and what it ended up being worth, and look back at what you estimated the budget to be and what the budget actually was. And I think if lawyers more regularly looked at that, they might end up more realistic when they set off. So we turn down cases that will win because we're not confident of the values that are assigned to these cases, that will be the case. And interestingly, the point about if lawyers take these on and become the funders, there's a separate tension, isn't there, where the lawyers running the case are themselves interested in the outcome, whereas me as funder, I'm one removed. I can't control the case. I can't dictate settlement terms. If you're running the case, you, of course, have got these two hats you're wearing of interested in sharing in the proceeds as well as running the case. And whilst lawyers can become funders in those jurisdictions where adverse costs are payable, if there is nobody behind the law firm and the case is lost, who then pays those costs? And I think that's something that is quite difficult to cover. So where we've seen the take-up of funding is very much different across different jurisdictions, and this point about insurance, most reputable funders have no problem about transparency at all. What they ask for is an equal playing field, and you'll know that many defendants have insurance, and it's about then understanding what the situation with regard to insurance in the event that the claimant is successful and is to be paid and have their costs paid. So it's just about making sure that there is sort of equality. We talked about equality of arms of knowledge, disclosure, and realism about what the in terms of funder terms, when they started the case and they were being told, oh, this case is worth 100 million, and when it finished it's worth 10, and of course that tension then about who gets paid what.
Do you ever put limits on the amount of funding you're prepared to supply?
Well, when what we ask at the beginning of every case, and in our funding agreement, we specifically spell out the amount of funding that we are going to provide. And when we start the conversation, the lawyers will often say, I need X. And we usually double X, because we know they're not going to be right, and put double X in the funding agreement so that that is up. But yes, we do cap the amount of funding because it can't be a blank check. If it were, let me assure you, it would be spent by people. There has to be a discipline around budgets and planning of cases. So yes, the amount you'll find in all funding agreements is spelled out.
Thank you. Justice Lowe.
Yes. Perhaps I could ask Ms. Dunn 2 questions. Please don't get me wrong. I'm not antagonistic at all towards third-party funders. But do you have within the third-party funding framework your own safeguards? What do I mean by this? Number one, do you have safeguards where you have your own panel of lawyers look into a case for assessment rather than rely on the party's lawyer's assessment, which might be overly sanguine? Number two, would you have concerns in linking up too much or too closely with litigation lawyers who will recommend you to their clients, or to say, well, if you need funding, I know 2 or 3 funders who might be interested? Do you have your own, like in the IBA rules, we have like if 3 times you're appointed by a same firm as arbitrator, it's a kind of signal that you have to start disclosing that link. Thank you.
So in terms of do we get somebody else to look at our cases? We're all lawyers, so certainly in our organisation we're all lawyers. Now, that means that we look at an enormous range of cases. So whilst one develops an expertise of a sort, you do always want to get the most up-to-date input on cases. So we will always engage third-party lawyers on our behalf to review the case and see whether it's of interest to us. And I think I must emphasize as well, this point about unmeritorious claims, I wouldn't still be in business if I ran an unmeritorious claims. Do we fund cases that lose? Absolutely, because that is the nature of litigation. But we only take on cases that we believe will win and have value. Otherwise, we simply wouldn't be in business, particularly since we operate mostly in jurisdictions where there's the loser pays system. So you lose not only the amount you funded, but you also lose the adverse cost too. And to your point, your question about after the event insurers suing lawyers for having said the case is going to be good, I have not, in 20 years, I've not heard of that. Are solicitors negligent? Yes, they are sometimes, but I have not heard of insurers suing lawyers unless it's something that's egregious. But I don't recall instantly any of that. Justice Knowles was talking about issues coming up from after the event insurance. You might recall that for a long time, one had the ability to reclaim the after the event insurance premium as well as the success fee on conditional fees. That led to an enormous amount of satellite litigation. I think quite rightly, with the Jackson reforms, we got rid of that, and that cut down a huge swathe of things. And so yes, we absolutely do get lawyers to take a look at what we are doing. And apologies, I've forgotten your second question. Though. So
perhaps I'd ask Justice Adderley to make a comment.
Yes.
It is. I don't think he's going to unmute.
And you can't hear me?
Yes, thank you.
Okay.
Can you unmute? Okay? Yeah, that's right. Yeah.
Okay. No, I have a question. The answer to which is probably self-evident, but I wanted to ask Ms. Dunn if she have they ever done any litigation funding in jurisdictions where the laws of champerty have not been abolished?
Yes, because
was not a prerequisite for litigation funding.
Absolutely. England and Wales has not abolished Champty and maintenance, and I've been funding here for 20 years. So, and when Justice Jackson did his review, he solicited views as to whether it should be abolished. And you might think I would be campaigning for that, but I wrote to him and said, keep it. Because I think if you abolish it, you'd probably need to replace it with something else. It's actually a handy, old piece of jurisprudence in terms of the third party must not control what the funded party is doing. And that should apply just as much if you have lawyers on contingency fees. If a claimant said, who are then effectively the funder, if the claimant says, my lawyer told me what to do and I didn't want to, etc., then one could point to Champty and say, I was controlled. I know that Cayman has just abolished it. I know that some jurisdictions do, but you might think perversely, I actually think it has a role still to play, and it's a useful catch-all that probably one should look to keep.
And in such jurisdictions, has there ever been any successful defense using those?
No, there's not, and that's been the development of jurisprudence and indeed legislation around the world. In that, I remember there was a wonderful silk here called Gabriel Moss, who I first worked with when I started doing this, and he wrote an opinion about where he thought the situation was in 2002. And I would get defendants who say, you can't be doing this. And Gabriel allowed me to send them his opinion, and I would never hear from them again, because they would say, all right, then that's the current status. And that's how it has evolved, is that people have recognized that you have to find a role for this because it is necessary. And it's, as I keep saying, what do I do for a living? I pay bills. It's not actually that exciting, but it's about how it is administered that one has to just keep an eye on.
Okay, thank you very much.
Does anyone have any views on whether there should be an attempt to have some degree of uniformity of controls over different jurisdictions? This may particularly happen in the case of would be relevant in the case of international arbitrations as much as international courts. We're commonly now experiencing funding coming from overseas bodies. I don't know if there's Dunn's funded any Australian cases, but there certainly has been American funders who have done so. And I wonder if it would be helpful for both the litigants and the courts if there was some attempt at some sort of uniformity on this issue. Could I ask Justice Chung from Singapore to say something about that, to express a view? Justice Chong.
How do I unmute?
You're unmuted, I think.
How do I do that? Can you hear me?
Yes.
Yeah. Before I respond to that question, I just wanted to make an observation of the point that Ms. Dunn made about when she was asked whether in the Jackson report a law against champty should be abolished. I would have thought intuitively that the business of the third-party funders, the viability would really depend on the continuing enforceability of the law of champty. Because if you remove a champty, then of course you don't need third-party funders because the funding would be done by the lawyers. Would that be right?
Sorry, because you said I didn't quite hear the very last thing you said. But if you remove champty, you wouldn't.
If you remove, yeah, my point really is your business model depends on you being able to provide the funding. But if you remove champty, the funding will be done by the lawyers. So in that sense, I would have thought that the viability of the business of the third-party funders would depend on the continuing enforceability of the law of champty. Would that be a correct observation?
I don't believe so. I mean, because whether champty is there or not, it is to some extent not relevant. The critical thing is there either legislation or jurisprudence which has indicated what the position is. So over the years, when I have funded for the first time in new jurisdictions, each time we solicit views and ask people, well, what's the current state of law? And so, for example, Jersey, in Jersey, because they have the sort of common law sitting alongside French law, the feeling was that the old French law said, no, you can't. We had a case, we tested it, and the court said, no, we think this is something that is okay, and therefore that has now become established. Many places keep Champerty maintenance, and it doesn't, as I say, it's a thing to protect the funded party. Removing it, as they have example just done it with legislation in Cayman, whilst explicitly authorising both contingency fees and funding, is just them sort of saying we don't think there's a role for that anymore, and one can discuss whether that's right or wrong, whilst allowing things. But I don't think per se having or not having Champerty makes much difference to whether funding it works.
Right. All right. In response to your question, Chief Justice Bathurst, I would have thought the answer intuitively must be yes. It would be useful to have a uniform set of rules to govern third-party funding so that all litigants in any jurisdiction will be on the same level playing field. Yeah. So I think that it's, but the question is, right now, there's so much, there's lack of uniformity in so many jurisdictions, because some jurisdictions don't allow, some jurisdictions allow it to a limited capacity. And I think we are quite a long way from being able to achieve a certain degree of uniformity. But I would have thought that whatever the most basic requirement would be, A, it should be regulated, and B, there should be disclosure. I would think that this must be the two minimum requirements.
Thank you. Lord Hope.
Yes, I agree with the last speaker on the desirability of it, but I think there is a primary question as to who is to do the regulation. Because in some jurisdictions, I suspect that legislation would be needed to allow it to happen. If it's open to the courts themselves, then it's a matter of the courts taking the bull by the horns and making their own rules. And there is a case for uniformity there by following each other's examples. In our case in Abu Dhabi, we looked very closely at what Singapore was doing, and we modeled a set of rules based on theirs, slightly simpler, but we have the freedom to do it. But I'm not sure that every jurisdiction can do it simply by court rulemaking.
I think that's been the Australian experience to some extent. We can go so far, but there's limits on what we can do without legislative assistance. But I still agree with what Chief Justice Alsop said earlier. The courts, I think, are in the best position to appreciate the problems that are arising from this activity, and if nothing else, their recommendations should be taken very seriously by the legislature. Sometimes that happens, not always.
Yes, I think there's a lot of force in what you said.
Thank you. To what extent has there been experience in the arbitral field? I must say, from my part, my experience, I wasn't aware that there was a significant amount of funding in international commercial arbitration. That may well be my naivety, but is that occurring? Ms. Dunn.
Yes, it is. We do. I would say of the cases that we do, probably about 5 to 10%. We haven't had great outcomes in arbitrations, despite using the most top-tier law firms and having even another law firm alongside them to review what's going on. We end up with some quite curious outcomes that leave us scratching our head. And because losing is one thing, but if you can't figure out quite what you learn for next time, that makes it difficult. And as a die-hard common law, I don't like not common law, just a litigator. I don't like the lack of appeal, the ability to have an appeal. I find that very difficult to get comfortable with. So I would say that our appetite is quite low in this area. as a result, because it's very difficult for me to get comfortable not having right of appeal.
Thank you. Chief Justice Menon, Singapore has, I think, had experience with litigation funding and commercial arbitration. Is that right?
Yes, Tom. The extent to which our regulations allow for litigation funding, it started with litigation funding in the arbitration space. And it brings us back to something that my colleague, Justice Stephen Chong, raised. Because the reality of a cross-border world and cross-border dispute resolution framework is inevitably going to be that you just can't isolate yourselves from developments around the world. And Singapore is emerging as a big center for arbitration, and the international firms are here. They're involved in litigation funding. And you create tremendous inequality if you have a sense that some players have access to litigation funding and others don't. So that was the context in which I think the government, as I said in my remarks, took an incremental approach and felt that arbitration was the space we should open it up to. I know the government is looking at it in terms of where else they might go. But I don't know, and I wonder whether Minister Tong has a better sense of it, but I don't know the extent to which law firms in Singapore have actually been using the opportunity to tap litigation funding in the arbitration space. I don't know that as an objective matter, and I wonder whether the Minister has any information on that.
Mr. Tong.
Thank you, CJ. I don't have the numbers. I mean, there's no survey done. Anecdotally, my own sense is that there have been a handful, and you're probably looking at the larger international cross-border type complex arbitrations where this has happened. But I would say that sort of lying to what Susan has said earlier, that I think this is probably in its minority. So I don't think there's been a big uptake. We are looking, as you mentioned earlier, CJ, as to what other areas we could possibly expand this into. But I think it's been enforced for the last 2 or 3 years or so since we made the amendment. I don't think there's been a significant uptake. I may be wrong, but I only have anecdotal evidence.
Thank you. Has New Zealand had any experience with this? I'd ask Justice Venning if he mind saying something as the New Zealand experience.
Thank you, Chief Justice Bathurst. As in many things, New Zealand follows Australia. We aren't as refined as you in the development of litigation funding. Over the last 3 to 5 years, there has been an increase in litigation funding in New Zealand. We have applied through court decisions the application of our existing High Court rules, which are really not purpose-built for litigation funding. And the Law Commission has a project at the moment considering litigation funding and legislative reform. So that's really our position. It's certainly more common than it was.
Thank you. Thank you. Justice Middleton, what's the latest on the implementation of the law reform, the ALRC, the Australian Law Reform Commission report?
We've now had the Federal Parliamentary Joint Committee on Corporations and Financial Services report, and that is where I think the last word has been. And as I said, I think there's now a very real push for legislative change, and I think that will happen this year. Now, getting to the point about what will eventually happen, therefore, is it's going to be a mixture of judicial supervision and legislative regulation. So there will be a mixture of both, is my prediction. Could I just ask a question about a private arbitration? One of the things that, as I said, the court has been doing, and around the world, I think, has been doing this supervisory role and case-by-case basis. But that's because it's got the coercive power of the state and can really force people to do things and can have precedent. With that private arbitration, assumably the only way would be by some legislation or the consent of the parties in some way. It seems to me a different environment.
Minister Tong, has your legislation grappled with that?
I couldn't catch the question raised earlier.
Justice Middleton raised the issue of if courts, putting it not as elegantly as he did, if courts can't control private arbitration as they can commercial litigation, and I was asking whether your legislation or your light touch legislation has sought to impose some sort of control about private arbitrations occurring in your jurisdiction.
Well,
funding of those arbitrations.
Well, our rules apply across the spectrum of whether they are proceedings in mediation or in arbitration. We have a range of legislation coupled with soft laws as well. And they do, as I said at the outset earlier at the start of the hour, we looked at it from the perspective of how do we regulate the nature of the funder, the quality of the funder. We looked at the disclosure obligations, of course, regulations around the agreement itself, as Justice Chong said earlier. And finally, of course, looking also in the context of these agreements, the extent to which there can be some kind of professional obligations put onto the lawyers themselves. I think one of the speakers earlier mentioned that at the end of the day, it is the lawyers who have conduct of these cases. And so we do have a fairly broad set of both regulations as well as softer laws around issues like conflict, disclosure, the extent to which you feel you can be involved in a case, your role as it were, perhaps ties with the funder, a little bit like what Justice Lowe said earlier about your proximity of your relationship with the funders. So we do have these that wrap around the arrangements, and they apply to whether they are mediation proceedings or whether they are arbitral proceedings. Thank you.
Of course, ultimately, I suppose, to some extent, one's relying on lawyers performing their ethical obligations. A lot of these problems may not arise if they do that. I think that's brought us to the end of the session. Can I thank everyone who's made contributions, particularly Minister Tong, Justice Middleton, Ms Dunn, who really must have felt at some stage she was in the lion's den this afternoon. I'm sorry. And of course, Lord Hope for being here at probably a somewhat ungodly hour. I don't think we've found answers to issues or canvassed every possibility. What seems to be occurring is an emerging series of regulations, different countries dealing with it in different ways, and a lot will depend on the extent the legislature can and will leave it to the courts. But I think we've gained a deeper understanding of the various issues that are confronting all of us and which we're all dealt with. And if this conversation has given us ways to consider better access to justice, then it's been time well spent, and I'm confident it has been. Can I thank you all again and wish you well for the remainder of the conference? Thank you.